Friends, in this video I am going to discuss the emergency powers under the Indian Constitution. Friends, as we all know, Indians can never forget the dark period of emergency of 1975 to 1977. During those emergency days, the then draconian ruling outfit had deprived the fundamental rights of all the Indians. The central government went to the extent of arguing before the Supreme Court that the people do not have even the right to life. When the emergency is in operation, the Shah Commission, which probed the excesses of emergency period, found that there was no real emergency and there was no threat to security from either external or internal forces. The public perception was that the emergency was imposed to save the then central government. By the 44th Amendment to the Constitution in 1978, many safeguards are provided against any misuse of emergency powers in future. Emergency powers vested in the executive organ by the Indian Constitution is an unusual feature which is not found in any of the leading constitutions of the world. Of course, the emergency powers are provided keeping the experience of other countries to meet any extraordinary situation when there is a serious threat to the security of India from war, external aggression, or armed rebellion within. Proclamation of an emergency is a very serious matter as it disturbs the normal fabric of the Constitution and adversely affects the rights of the people. Such a proclamation should therefore be issued only in exceptional circumstances and not merely to keep an unpopular government in office, as happened in June 1975 when an emergency was declared for the first time on the ground of internal disturbance without there being adequate justification for the same. The framers of the Constitution, including Dr. Ambedkar, felt that where there is a serious threat to the security of the country by forces both within and without, the center should have overriding powers to control and direct all aspects of administration and legislation throughout the country. The Constitution envisages three types of emergencies. First one is national emergency, that is, emergency arising from a threat to the security of India. Secondly, state emergency, that is, breakdown of constitutional machinery in a state. Then financial emergency. Article 352 deals with the national emergency under Article 352 Clause 1, if the President is satisfied that a grave emergency exists whereby the security of India or any part thereof is threatened, whether by war or external aggression or armed rebellion, he may, by proclamation, make a declaration to that effect. Such a proclamation may be made in respect of the whole of India or such part of the Indian territory as may be specified in the proclamation. This type of emergency has been proclaimed three times so far, that is in 1962, 1971 and 1975. The first proclamation of national emergency was issued in October 1962 on account of Chinese aggression in Nepal and was enforced till January 1968. Then the second proclamation of national emergency was made in 1971, that is in the month of December 1971 during Bangladesh Liberation War. When that emergency was still in operation, the proclamation of national emergency was made in June 1975 on the ground of internal disturbance. Both the second and the third proclamations were revoked in March 1977. The proclamation can be made by the President before the actual occurrence of war or external aggression or armed rebellion. Before 1978, an emergency could be declared because of war, external aggression or internal disturbance. The 44th Amendment of 1978 substituted the words armed rebellion for internal disturbance, as the latter word has wider connotation. The Supreme Court opined in a case that armed rebellion is likely to pose a threat to the security of the country or a part of it, while internal disturbance, though serious in nature, would not pose a threat to the security of the country. The intention behind the substitution of internal disturbance is to restrict the use of emergency power only to more serious situations where there is a real threat to security of the country. It was also the reason to avoid the misuse of emergency powers as happened in 1975. Under Article 352, Clause 3, a very important safeguard was introduced by 44th Amendment, and this amendment provided that the President shall not issue a proclamation of emergency or its variation unless the decision of the Union Cabinet that such a proclamation may be issued has been communicated to him in writing. In 1975, the President proclaimed the emergency on the advice of the Prime Minister alone, and the Cabinet was informed later. As a result, the Cabinet did not get any opportunity to discuss the need for the proclamation before it was imposed. Let us now consider as to how long the emergency could be in operation. Friends, every proclamation of emergency is to be laid before each House of Parliament, and it ceases to operate at the expiry of 1 month unless in the meantime it has been approved by both the Houses of the Parliament. If at the time of the issue of proclamation or thereafter Lok Sabha is dissolved without approving the proclamation and Rajya Sabha approves it, then the proclamation ceases to operate 30 days after Lok Sabha sits again after fresh elections, unless in the meantime Lok Sabha passes a resolution approving the proclamation. A resolution approving the proclamation has to be passed by each House by a majority of the total membership of each House and not less than 2/3 of the majority of the members present and voting in each House. Once approved by Parliament, the proclamation remains in force unless revoked earlier only for 6 months from the passing of the latter of the resolutions. For continuance of the emergency beyond that period, parliamentary approval is required, and each time Parliament approves proclamation, its life is extended for further 6 months. Each resolution of approval must be passed by the Parliament by a special majority. Then let us consider revocation of emergency. When the emergency can be revoked. The Constitution has provided for a simple procedure for revocation of emergency. The President can revoke the emergency if the Lok Sabha passes a resolution by a simple majority of the members present and voting. Before the 44th Amendment, the power to revoke the emergency was vested in the executive, and the Lok Sabha had no say in the matter. Further, it is provided by 44th Amendment that where a notice in writing is given by not less than 1/10 of the total members of their intention to move a resolution disapproving the proclamation of emergency to the Speaker if the House is in session, or to the President if the House is not in session, a special sitting of the House is to be convened within 14 days after notice has been received by the Speaker or the President, as the case may be, for the purpose of considering such a resolution. The President has power to issue different proclamations on different grounds mentioned in Article 352 Clause 1 on different occasions. Now let us consider the justiciability of the President satisfaction or discretion. It has been seen already that a proclamation of emergency can be made by the President only when he is satisfied that there is a threat to the security of India or a part thereof. Thus, whether there is a threat to security of India or not lies within the subjective satisfaction of the President acting on the advice of the Cabinet. Article 352 Clause 5 which was added by 38th Amendment, declared that the satisfaction of the President mentioned in Article 352 shall be final and conclusive and shall not be questioned in any court of law. Even the Supreme Court had held in Bhutnath versus State of West Bengal in 1974 that the proclamation of emergency was not a justiciable issue but was essentially a political matter. But now, 44th Amendment has repealed Article 352 Clause 5 and amended provision provides that the Supreme Court can decide whether it will treat the satisfaction of the President as final and non-justiciable or being subject to judicial review on some grounds. In Mineral Mills Union of India, Justice Bhagavati opined that the 30th Amendment, which barred the satisfaction of the President from being called into question in a court, could be declared as unconstitutional as being violative of the basic structure of the Constitution. Judicial review being regarded as an essential feature of the Constitution. Let us now consider the consequences of a proclamation of emergency. Several consequences which are really serious will follow from the issue of a proclamation of emergency. The first consequence is that the federal structure as envisaged by the Constitution undergoes a drastic change and the country assumes the character of unitary state. The Parliament becomes empowered to legislate on any matter in any of the three lists. That means the distribution of legislative power provided by the Constitution just withers away or disappears. However, the state legislatures may continue to make law in their assigned area, but when there is a repugnancy between the two, that is the law passed by the central legislature, that is the Parliament, that would override a state law even with respect to a matter in the state list. That is what has been provided in the Constitution. Next consequence is suspension of fundamental rights under Article 19. According to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights under Article 19 are automatically suspended. So no special declaration is necessary suspending them. Article 19 is automatically revived after the expiry of the emergency. The 44th Amendment Act has laid down that Article 19 can only be suspended when the national emergency is proclaimed on the grounds of war or external aggression and not in the case of armed rebellion. Third consequence is suspension of other fundamental rights. Under Article 359, the President is authorized to suspend by order the right to move, that is enforcement in any court, that is the right to move any court for the enforcement of fundamental rights except Article 20 and 21 rights during a national emergency. Thus, remedial measures are suspended and not the very fundamental rights. Fourthly, the center becomes empowered to give directions to a state as to the manner of exercise of its executive power. Fifthly, when emergency is declared only in a part of India, the executive power to give directions and the power of Parliament to make laws extend not only to that state but also to any other state. Sixthly, when the proclamation of emergency is in operation, the President may by order regulate the sharing of revenue between the center and the states. Seventhly, the center may levy any tax which ordinarily falls in the state list. Then, during the operation of the proclamation of emergency, the life of Lok Sabha and the state legislatures may be extended beyond their normal 5-year period by Parliament for a period not exceeding 1 year, up to a period not exceeding 6 months after the proclamation of emergency ceases to operate. The Vesting of emergency powers in the chief executive has been criticized even during the Constituent Assembly debates. Let us consider some of the criticisms which were actually offered by some members of the Constituent Assembly. They criticize the incorporation of emergency provisions in the Constitution on the various grounds, that is, the following grounds. First one is the federal character of the Constitution will be destroyed and the Union will become all powerful. Next, the powers of the state, both the Union and the units, will entirely be concentrated in the hands of the Union executive. The president will become a dictator. The financial autonomy of the state will be nullified. Fundamental rights will become meaningless, and as a result, the democratic foundation of the constitution will be destroyed. Despite the draconian nature of the emergency, we can conclude that they are necessary to meet a situation where there is a serious threat to the security of the country, and it becomes necessary for the nation to act as a unitary state and with all the powers to deal effectively with it. Of course, with necessary safeguards to avoid misuse of emergency powers. With this, I conclude this presentation on the